Let's go to the next topic on retirement. This is an instance where the employer-employee relationship may be severed because the employee has reached what we call retirement age. When the employee reaches this kind of age, the employee can avail of retirement in order to reward for long service to the company. So what is retirement? According to the Supreme Court, in the case of Paz versus Northern Tobacco Redrying Incorporated, February 18, 2015, retirement is the result of a bilateral act of parties, a voluntary agreement between the employer and the employee whereby the latter, after reaching certain age, agrees to sever his or her employment with the latter. Now let's go to Article 302 of the Labor Code. Under this article, it is emphasized that the employee may be retired upon reaching the retirement age established in the collective bargaining agreement and other applicable employment contract. The way it is worded, it is very clear and apparent that the primacy of collective bargaining agreement or employment contract is highlighted, which means that if there is a CBA or an employment contract which offers a better retirement benefit, that CBA or retirement contract must prevail. The law will not apply. The instance that the law will apply if there is no CBA or there is no employment contract which offers a better term or better benefit, or if there is an employment contract which offers or which gives a lower benefit, retirement benefit, then the law will prevail for Article 302. If in case the law will prevail, then the voluntary age of retirement will be upon reaching the age of 60 years old, with the requirement that the employee must have served the establishment for at least 5 years. In computing this retirement, the retirement pay is 1/2 month salary for every year of service. Later, we will discuss the inclusion of the 1/2 month salary. So let's start with company policy. If there is a company policy giving a higher retirement benefit, it must prevail. Then remember, this retirement law allows exception before we go further. These are the employees of the national government and political subdivision, including government-owned or controlled corporation. They are governed by the Civil Service Law and its regulations, and employees of retail, service, and agricultural establishments or operations regularly employing not more than 10 employees. Those are the recognized exceptions. Now, I mentioned earlier about CBA. Can the CBA provide for a compulsory retirement age lower than what the law provides? The Supreme Court upheld that CBA is a valid agreement between parties as long as there's no showing of fraud, intimidation, during the signing of the CBA, then if the CBA will provide a 20-year of service compulsory retirement in the company, then that is allowed. However, if what is provided in a company policy is voluntary retirement or a CBA, you cannot compel the employee to avail of voluntary retirement. After all, the nature of retirement is voluntary. So the employee can wait for compulsory retirement. Compulsory retirement under the law is 65. So if the employee will not avail of voluntary retirement, then the employee can wait until he or she reaches the age of 65. When the employee reaches the age of 65, then there will be compulsory retirement. The employee has to severe employer-employee relationship. Otherwise, the employer can compel the employee. Now, if we are going to look at our existing laws, there are therefore several age retirement as provided for by law and by special law. First, if you will be asked what are the applicable retirement ages, we have to start with 302. Under 302, it will tell you of a retirement policy provided under CBA or provided under an employment contract. In the absence of the CBA or company retirement policy, then Article 302 will apply, which means that the voluntary retirement age will be 60 years old, provided that the employee has rendered at least 5 years in the company prior to retirement. Under 302 also, there is the provision of compulsory retirement, which is 65 years old. Another kind of retirement is under Underground Mining Act, wherein the employer or the employee can avail of voluntary retirement upon reaching the age of 50. And compulsory retirement under this law for underground mining is now 65. Oh no, 60. So for underground mining, the voluntary retirement age is 50, and the compulsory retirement age would be 60. We are talking here of RA 8558. The last age requirement is the retirement given to racehorse jockey or jockeys. They are allowed by law to retire upon reaching 55. That will be compulsory retirement. This is governed by RA 10789. Because of the nature of their job, compulsory retirement for racehorse jockey would be 55 years old. The next question is, are part-time employees entitled to avail of retirement? The answer is in affirmative. The law did not distinguish. In fact, under the Labor Advisory dated October 24, 1996, the part-time employees are included in the retirement pay law. Since this retirement pay law is a social legislation, it will retroact if the employee is benefited. So if there is a law passed by Congress, a retirement law, in order for this retirement law to take effect retroactively, the Supreme Court in the case of J.V. Angeles Corporation or Construction Corporation versus NLRC, April 14, 1999, gave the following requirements: that the claimant for retirement benefit was still the employee of the employer at the time when the law took effect, and that the claimant has complied with the requirements for eligibility under the statute for such retirement benefits. So, take note of that case, that is as regards retroactivity. Well, Pag-ibig Fund contribution of the employer can be used as a benefit. Only the share of the employer will be used in the computation under Section 21, Republic Act 1752. If there is a difference, then the employer will pay. If ever you will be asked of the inclusion of the retirement pay under retirement pay law, it will include 15 days salary of the employee based on the latest salary rate. It should include also the cash equivalent of not more than 5 days of service incentive leave, another 1/12 of the 13-month pay due to the employee, and all other benefits that the employer and employee may agree upon that should be included in the computation of the employee's retirement pay. Now, what will happen if the employee is terminated prior to availment of retirement? Now, if the termination is valid and decided with finality, then the employee cannot avail of retirement. If the dismissal is considered or decreed to be invalid by the court, the labor court, and affirmed on appeal with finality, or even the decision of the labor court that has become final and executory, the employee will be entitled to retirement as well as back wages if applicable. However, the computation of the retirement benefit will only be up to 65 years old, because based on the logic, had the employee not been terminated, the employee would have been working until the age of 65. That presupposes if the case has been decided when the employee was more than 65 years old. Because when the case has decided with finality and the employee is still 63 years old, then the computation of retirement will be up to 63 years old. The next question is, can you rehire an employee who has reached compulsory retirement? Under the implementing rules, yes, the employee may be hired based on case-to-case basis. This is commonly practiced among educational institutions where teachers who have retired compulsorily are given the opportunity to teach on a part-time basis. The burden of proof as to when it comes to retirement are as follows. No? The rule would be, if the employee would allege the applicability of portability law, and of course we have you know already the meaning of portability law. This is a law which allows an employee who transferred from public to private and public to government to avail of retirement using the totalization rule. So if there is an allegation of the employee as to the applicability of portability law, then it is the obligation of the employee to prove that he or she is qualified. If the basis for claim of retirement is a company policy, then the employee has the burden of proof to prove that such company policy has ripened into a benefit. The Supreme Court ruled that 1 year is not enough for a company policy to become a benefit. It cannot be considered to have ripened into a benefit in just 1 year. We are talking of the case of Perez versus Comparts Industries.